The history of privacy impact assessments in Canada and what I call the drivers, what inspires or requires an organization to do a PIA, it is kind of interesting because if you look at the first, I guess, 4 drivers, they really apply to the public sector only. And I'll use public and private sectors to mean respectively government institutions as public, private sector, private companies. And so the impetus behind government institutions doing PIAs, in some cases they're legislative requirements, government directives, which though they're not legally required, they are a condition basically of maintaining your government support. Privacy commissioners can make recommendations, and even though they may be said to be recommendations, our privacy commissioners in Canada, as you probably know, hold a lot of legal weight and sway with respect to how organizations operate. So you basically should do them if the commissioners recommend them. And in certain cases, funding requirements. But if you look at the last 2 drivers, best practices and complex information sharing environments, I'd suggest that from a private sector perspective, the mere threat of legal action in the case of a breach can drive an organization to do a proactive privacy impact assessment to make sure that they've closed all those gaps and they won't necessarily suffer these things. And again, it related to one point we heard this morning, which is of interest. By doing these things and maintaining reasonable security measures, which a PIA might be said to be a part of, the end result could be mitigation of potential fine or whatever you've got. In terms of complex information sharing environments, we know that consumers, using health as an example, are really wary of complex integrated electronic health systems. They're concerned about what's going to happen to their data when it gets put online. So again, that may be viewed consumer expectations as a driver for privacy impact assessments. What I've done here is just set out a few pages of charts that capture drivers in particular cases in Canadian legislation or government directives, etc. And I just want to highlight a couple of points. What you'll see is, regardless of whether the driver is legislation, privacy commissioner's recommendation, funding criteria, the coverage with respect to the application is, for the most part, as I said, the public sector. And the one exception is in Alberta, where custodians are going to include physician offices. The same can be true in Ontario and potentially for New Brunswick as well. Again, that's in health. And the focus across the board in Canada with the PIA drivers is not only public sector, but it's the health sector. And in Ontario, there's another requirement for PIAs for what we called health information network providers. These are organizations that provide the wires and systems to connect other organizations like physicians and hospitals, etc., that have health information depositories. So that link, the health information network provider, is required in Ontario to do a PIA. It's set out in the regulations, and provide a copy of that document to the entities whose information it's going to carry, basically as an assurance tool. The other very important point I'd like you to note is the role of the regulator in the Canadian PIA process. And that comment is set out in the column headed Regulatory Oversight. And you'll see that even in those instances where there is a legislative requirement, so for example, the Health Information Act in Alberta or a government directive, where the PIA must be provided to the commissioner, i.e. the regulator, you'll see that the commissioners do not approve or reject PIAs. And I think this is a really important point. And so what I've done, I have a quote here from the Alberta Commissioner's website with respect to the process. And he says, because the onus always remains on the organization to ensure adequate levels of privacy protection, the Commissioner will not approve a PIA submitted to him by an organization. Once satisfied that the provision of the necessary level of privacy protection is included, the Commissioner will accept the PIA. But acceptance is not approval. It merely reflects the Commissioner's acceptance that the organization, and you'll recall these words, has made reasonable efforts to protect privacy. A PIA cannot be used to obtain a waiver of or relaxation from any requirement of the relevant legislation.